What we're going to be doing is first I'll overview what a land trust is. For those of you who haven't heard of it, maybe you have heard of it, but you're not quite sure what it is or how it works. So we'll be going over that. And then I'm going to explain to you how this is really the most versatile tool in your real estate investing toolbox and how you can combine it with an asset protection structure to really protect all of the wealth that you're working so hard to build. So land trusts are really revocable grantor trusts. Now, Illinois, Virginia, and Florida have actual land trust statutes. The Florida statute's called the land trust statute. In those states, they work a little bit differently. When we draft what we call a land trust at Anderson, we're really drafting a revocable grantor trust that is under the same umbrella as a living trust. Just the terms and conditions are different. It's for the purpose of holding land, which is where we came up with this nifty name of land trust, right? Land trusts alone do not offer asset protection, meaning that if you simply have your property in a trust and you're the direct beneficiary, when the trust is sued, you as an individual will still be liable for whatever lawsuit results from that. Florida is an exception. So if you're investing in Florida, those land trusts offer what I say is 50% asset protection. So you as a beneficiary are not liable for a lawsuit, but your property in your trust isn't protected from your personal liability. So if you go out, get in a car accident, your creditor can reach into your land trust assets. So we do still want to combine our land trusts with an LLC asset protection structure. The great part about trusts, though, is that they're not filed with the state. The only thing you see on public record is going to be the name of the trust and the name of the trustee. And you're going to find that in two places. You're going to find that on the face of the deed, which you can look up at the county recorder's office, and you're going to find that on the assessor's website at the county, which logs all of the ownership for properties. But beyond that, that's all you see. You don't see who the beneficiaries are of a trust. You don't see when the owner assigns the beneficial interest to an LLC. You're kind of stuck at a dead end. So from an anonymity perspective and a privacy perspective, they're a really great option to use. And what it does, and this is more of a legal concept, it takes the real property ownership, converts it to personal property, which then allows you to assign the beneficial ownership to another entity or person. Now, the parties involved include the trustee. The trustee's name shows up on the public record. Anderson offers a nominee trustee service, so you can have one of our attorneys temporarily serve as a trustee so that your name isn't showing up on the public record. And then the beneficiaries are who get the benefit of the rents. So the rents go to them. And what we want to do is, again, we want to assign the beneficial interest over to an LLC. This is just a little copy of our land trust provisions. I know it's a little bit small, but basically the trustee holds legal title, and that's why their name shows up on the public record. And then as the beneficiary, you can assign your interest, essentially connect that trust to an LLC so that if the trust is sued, then the LLC is responsible for that lawsuit. And guess what else is what's in the LLC? Nothing, right? It's not connected to any of our personal assets or our personal liability. Now we're going to go into some problems you as an investor may encounter and how land trust can be the perfect solution to those problems. So first is what we call trapped real estate. So I'm sure a lot of you, and you can go ahead and give me an emoji if you've been in this situation. One of the first things that happens when you become a real estate investor, you start reading books, listening to podcasts, joining Protect Wealth, and people ask, well, do I need an LLC? And so you go out and you get an LLC. But you're not a lawyer and you're not a CPA, so you didn't know how to set it up. But you start just getting properties and you have an LLC, so you put them all into the LLC. That's super common thing to do. Well, the problem here is that now the liability for all of these properties is all together. So if your tenant has a dog bite on one property, they're going to sue that LLC that's on title. And then if there's a judgment, then all of the assets of that LLC are going to be available to that creditor. So we really want to separate things out. And that's the core concept behind asset protection, is separating out your assets so that worst case scenario, one thing might be lost, but it's not going to take down your entire portfolio or all of the things that you've worked so hard for. So now what we could do is we could directly transfer each of those properties to an LLC that's owned by a holding company. A Wyoming LLC will give you anonymity. It will give you what's called charging order protection. And then that state-specific LLC, one property per LLC. So we've done part of the work, right? So we've transferred into individual LLCs, so our properties separated out, but we've left breadcrumbs. We can see on the public record that an individual LLC made direct transfers to all of these other individual LLCs. And through just common sense, we can kind of see that each of them are owned by, when we look them up at the state, are owned by the same common holding company. And so we can kind of put together that they're still connected. So instead, what we can do is multiple transfers. We can take all of the properties out of the LLC, put them into our own name, and then individually title them into the new LLCs. But again, we run into the same issue, right? Because everything's going from a single person now, ourselves, into different LLCs. But if you look those red box LLCs up at the state level, you'll see that they're all owned by the same holding company. And it doesn't take a genius to figure it out. They're following the breadcrumbs. In addition, you've now filed 2 deeds. So there will be deed filing fees, perhaps some transfer taxes, things like that. So it can get a little expensive. So what is our solution? It's the land trust. So instead, we're going to deed each of the individual properties into its own individual trust. That separates them out. Now, this will not be subject to transfer tax because almost every state is going to have an exception to transfer tax and reassessment when transferring property to a revocable grantor trust. These exceptions are designed to encourage people to do estate planning. We want people to put their property into a living trust because that reduces costs for the county. They don't have to hire more judges. They don't have to build more courthouses. They don't have to have more clerks. All of that property can just transfer automatically via the living trust. Now, because our land trust is also a revocable grantor trust, just like our living trust, it qualifies for these same exemptions. So no additional transfer tax, no additional property tax reassessments. Now they're each in their individual trusts. And then we're going to assign the beneficial interest for each LLC, for each trust, to ourselves, to a new beneficiary. And guess what? That assignment is not recorded anywhere. That trust is not recorded anywhere. You can't go to the county and see who owns the trust like you can go to the Secretary of State and see who owns an LLC. So all of this additional steps to connect you to the trust and then your LLC to the trust, none of that is on the public record. They're private documents that you keep in your own private filing cabinet, or just on your computer if you don't have an actual filing cabinet. Again, none of it's on the public record, so no additional transfer tax or reassessments there. So it's really the perfect fit. And how hard is this? You sign two pieces of paper, one for each transfer. When you have our land trust for Anderson, we draft all of this for you. We send it to you via DocuSign, so it becomes really easy to effectuate these transfers. Now, how rents are collected in a land trust kind of depends on the scenario. So if you have trusts in LLCs, if you're investing out of state, you may have your land trust connected directly to your holding company or directly to your LLC. You can use these to own out of state property. So a lot of our clients, California likes to charge its residents for LLCs owned in different states. So we'll hold property in land trusts instead. So if you're investing out of state, the beneficial interest is not held by an in-state LLC. And so we're actually going to collect rents directly in the land trust. So if you have, this is how I do it personally in Nevada. I have our former primary residence. We rent it out as a midterm rental, so it's up on Airbnb. Nevada LLCs cost $450 a year, which is outrageously expensive when I can get a Wyoming LLC and it costs me $62 a year to maintain. So instead of putting my property in a Nevada LLC, I have mine in a land trust. That land trust is then connected to a Wyoming LLC. So overall, I'm saving $350 already every year. I mean, that's, if you're looking for cash flow, that amount can be significant. Because I don't have my LLC in Nevada, I need to have my bank account in my land trust so that I can actually collect Nevada sourced rents and income. And then those will flow up to the LLC. Alternatively, we can set up a third-party property management company. Now, I've only got my one former primary residence as a rental, so I'm not quite doing that yet. But if you're investing in, let's say you work with Aaron Adams and invest in Indianapolis and have 5, 6 properties there, and if you want to collect rents in an Indiana LLC, you can do that as well. And then you're transferring the funds over to the land trust. This also works if you have a third-party property manager. They would collect the rents locally if you're more of a hands-off person, and then they would distribute the rents to your each individual land trust. Now, wholesale. Wholesaling is where you go out and you get a property under contract, and then you either double close, meaning you close and then you sell to another investor, or you sell that contract to a new investor for a fee, maybe, and then they step into your shoes. Now, we don't necessarily want to make offers in our own name. That can get dangerous. We had a client who was doing this exact thing. She decided she wasn't able to get the next investor to close on the property. And so she canceled the contract thinking, oh, I'm just losing my earnest money deposit. Well, the market had shifted dramatically in the interim, and the sellers actually sued her for what's called specific performance. And in a real estate contract, specific performance means they're suing you to make you buy the house. Well, she didn't have the money to buy the house. So this put her in a pretty bad spot. So how you would then protect yourself personally in this situation is to use a land trust. And so what you're going to do is you're going to get the property under contract in the name of the trust. All right. And then you're going to find that investor. And instead of putting their name on the contract, you're simply selling them the entire trust. So you're changing the owner of the trust to this new investor, and then you're taking your fee and you're walking away. Investors love this strategy. If you're somebody who gets properties from wholesalers, they love this strategy because they never have to close in their name. Their name doesn't show up in the chain of title on the public record at all. You close in the name of the trust, and that's the only thing that shows up on the public record. All right. Buying at auction. What's the problem when we're buying at auction? Well, it's really hard if you're standing there and you're bidding on a property. It's really hard to then call your attorney, get them on the phone, and have them set up a state-specific LLC for that property right there on the spot. Most of the time, we're not going to be able to do that. Not because your attorney's not fast, but because it takes a few days, sometimes weeks, for the state to actually process your LLC. So what do we do instead? We can use a land trust. Now, for this specifically, Anderson created a short form land trust, or what we call a pocket trust. And we have a deliverable that we send our unlimited land trust clients where they simply, it's a template and they fill out a few fields. And essentially what you do is the property you close on, you whip the pocket trust out of your pocket, you throw it down, you fill in the parties, who the trustee is, who the beneficiaries are, the property address, and you can close in that trust. And then what you can do is come back to us and we will then restate that land trust into the full land trust template or the full substantial 14, 15 page document instead of the one. This allows you to purchase with anonymity. So your name never shows up on the public record, never shows up on title. And it allows you to have different exit strategies, right? So if you are going to keep the property as a rental, when we restate your trust, we would make an LLC, a state specific LLC, the beneficiary. Perhaps you renovate the property and then you want to sell it, you want to flip it. Well, then we can simply assign the entire trust over to the new investor. And this works really great because, again, that investor or that homeowner never has to show up in the chain of title. Robert's asking if you have to file separate tax returns for each of the LLCs and each trust, and the answer to that is going to be no. The land trusts are disregarded entities, as are most of the state-specific LLCs. Disregarded means that they aren't seen by the federal government. I call them the John Cena of legal entities because John Cena goes, you can't see me. That's what the land trusts and the LLCs do. The federal government doesn't see them, so you're not filing federal tax returns. Now, for state, you may be filing a state tax return, but all of that income from the rentals are going to flow onto your personal 1040 Schedule E, page 1. All right. All right, so seasoning issues. So this can also be a secondary issue for an auction property, but it's what a lot of our flippers tend to run into. So when you're a flipper, you may have gotten a property from wholesaling or at auction. You may even buy it from another investor who originally started the flip, maybe ran out of money and couldn't fix it. Well, what happens to our loan or our lending options when we see a property changing ownership multiple times within a short time frame? Because ideally, if you're flipping, you're purchasing the property, you're renovating it, and then you're flipping it to the new owner within a few months, sometimes even faster for those of you who have gotten very good at it. And especially, so we're seeing the title change more quickly, right? Well, too many deed transfers, actually, lenders don't like to see that. They don't like we're seeing things outside of the box. They don't like anything that's a little bit unusual. And so it can actually cause your ultimate buyer to have to jump through more hoops in order to get financing. So a couple of examples of that are they may need a secondary appraisal if the property has switched hands more than 2 times within the previous 12 months. There's just extra assurances that the lender will want to see. Now, if we use a land trust, we're never changing title on the public record. We can close in the trust, then we can simply flip the entire trust to a new buyer. Alternatively, we can assign the trust to a new LLC if it's an investor who's buying it. Say Don flips a property, he holds it in a land trust, and I come along, I'm looking for a rental. Well, instead of Don transferring the property into my name and then me transferring it to my LLC, Don can simply use that 1-page assignment of interest and then assign it to my LLC. And guess what? Neither one of us were on the chain of title. It makes those vicious, frivolous lawsuit litigants, it makes it so much harder for them to find you. And if they can't find you, it's security through obscurity, right? They don't see a big pot at the end of the tunnel, big pot of gold. And so they're less likely to come after you for that. Here are the different issues that, depending on what your buyer's doing, will, or the type of lending or funding that they're using for the purchase, some of the examples of extra things that they might have to do. A second appraisal for a VA loan, 2 appraisals if the property's been owned for less than 181 days. I mean, when you're flipping, 181 days is way too long to take on a renovation. So we're expanding our pool of potential buyers by keeping the property in a land trust and not having the title change as frequently. Uh, Beyond the difference between a land trust and a revocable living trust are simply the purposes for which they're drafted, right? The land trust is for land, it's to hold title to property. It's not going to have all of the beneficiaries and death provisions that your living trust. It's not a substitute for true full estate planning, but they do fall within the same category of revocable trust. And that's why a lot of the transfer tax exemptions apply to that. Property taxes, when we're transferring in and out of a trust, they should not be adjusting or be reassessing. There are some small exceptions depending on where you're investing. We do land trusts in all 50 states. States like to, and different counties like to change their rules every so often. But property taxes should stay the same because, again, they want people to do estate planning. If it costs you a huge transfer fee to move your property into your living trust, or if it was going to reassess and take away your homestead exemption, then people wouldn't do it. So there's specific exemptions to these rules, especially tax rules, to encourage proper estate planning. And because land trusts are revocable grantor trusts, they fall within those same exemptions. Now, another issue that investors have are with CC&Rs. So essentially HOA rules, right? They can be very restrictive. They can not allow for LLC ownership. I live in a community that's like that now. They want to discourage renters. They want to especially discourage certain types of renting, like short-term rentals. And so in order to do that, if your county doesn't have any sort of short-term rental rules or provisions or guardrails in place, then individual HOA communities will come in and say, hey, you can't have an LLC own the property. So what do we do instead? That's right. I hear you guys screaming it out from across the web. A land trust is the answer. By the way, a land trust is going to be an answer to the answer to all of the problems that we are looking at this evening. But we put the property into a trust from the public record. It's in a revocable trust. Again, just like your living trust. So it doesn't violate those HOA rules. Now you will separately assign the beneficial interest to an LLC, but that isn't on the public record anywhere. There's nowhere for the HOA to look up who that is. That's a separate one-page document. So even if the HOA comes back to you and says, hey, we need a copy of your trust agreement, we need to make sure that you're still the person that we contact in terms of the property, you can go ahead and hand over that trust agreement because it's still going to have your name on it as the original grantor and beneficiary. They're going to look at it. They're going to say, thumbs up, that looks great. You're still going to be able to vote in the HOA meetings and have all of the control over the property. But when you assign that beneficial interest over to the LLC, you suddenly don't have any of the liability that comes with that property. Sriva's asking another tax question. Are all land trusts reported on Schedule E? It's not the land trust that decides which schedule the income's reported on. It's the type of activity. So if you use the land trust for a long-term rental, that is reported on Schedule E. Page 1, if your structure is disregarded, if you've got a partnership, if your holding company is a partnership because perhaps you're married or you have a business partner, that would be Schedule E, page 2. Now, if you're running a short-term rental and the average length of stay is 7 days or less, or you provide substantial services with that short-term rental, like concierge or cooking or things like that, go above and beyond, then that's going to be reported on Schedule C. So it's not that the land trust decides where the income is reported, it is the type of activity that you are doing. All right. All right, subject to investing. So when we were chatting before the webinar started, Kendall had asked the question, With the current economic environment, are we still seeing a lot of real estate investors out there? And the answer is yes, although their strategies have been changing. And subject to deals are one of the things that kind of exploded since in the post-COVID era, since 2020. Um, and so, for those of you who haven't heard of it, subject to investing is when you find a distressed owner. Maybe they're behind on their property taxes. Maybe they're behind on their mortgage and they don't have the funds to get caught up. Or they are in a good spot mortgage tax wise, but their property needs some work on it and they're not able to get a buyer because there's issues with the roof and the buyer's financing won't come through because the appraisal's not coming back or the home inspection's not coming back well enough. And so that homeowner's stuck. So as an investor, you are providing a solution. And you go in, you take title to their property subject to the existing mortgage. And now the reason this is working so well in this environment is because anyone who purchased their property even just 5 or 6 years ago likely has a very low mortgage interest rate. My sister and her husband purchased a property in Southern California and their interest rate is below 1% and they borrowed over $1 million. That's an incredibly low interest rate compared to maybe 7, 8. I've seen even closer to double digits for investment properties. Incredible. So as an investor, you're coming in, and if you can just simply take over that buyer's mortgage, like the difference between 1% and 7% is huge. So this is where the land trust comes in, because lenders have gotten wise in the last few years. They're not dummies. They know that people are going out there and doing this. So we've had several clients who, when the market started to change, didn't really think about doing something differently, and they just went out and would do a subject to deal with an LLC because that used to be fine because interest rates were low. As long as the mortgage was getting paid, the bank was fine with it. But now they're starting to check. They're starting to look for the property transfer. They're starting to look to see who's on title. They're looking to see if there's any updates to the insurance. They're looking to see if you're having the mortgage statement sent to a new address. We had a client who used a land trust, even were smart enough to do that, but they changed the address for where the property tax statements were going to be sent. And because it was a VA loan, and the terms of the VA loan was that the borrower had to live there for at least 1 year, and the borrower was moving before that year was up, the lender swooped in and started asking questions. These are questions that you don't want to have to answer, because taking title subject to the existing mortgage is a loophole strategy. That's what we call it, a loophole strategy. The seller isn't really supposed to be able to let you do that. It's just that the mortgage companies, as long as they get their money, they're not going to enact what's called the due on sale clause. And the due on sale clause states that when a property changes ownership, then you got to pay off the mortgage. And that's what usually happens. You sell your property in a normal scenario, title pays off the mortgage, and you walk away without owning anything else. Well, with subject to, the mortgage isn't getting paid off in a lump sum. And so we want to kind of lower all of those red flags that the lenders have been starting to look for. And so we use a land trust instead. Ideally, we want to keep maybe the seller on as trustee. We have some clients who use a trustee LLC. It works either way. You got to draft the trust specifically depending on who you're using as trustee. But the general idea is that the lender sees the borrower, the seller, on title as the trustee, and they don't ask any more questions. Or if they are asking questions, they see the seller on the actual trust. And the only thing connecting you to it is that assignment of beneficial interest, that 1-page document that is signed. You can get it notarized. It's all legal, but it's not something that The mortgage company or the county or the insurance company or the title company, no one's going to ask for it. And so you're keeping it as your private documents. So that allows you to not trigger any sort of red flag when it comes to changing title in a subject to deal. And then as long as you're still paying the mortgage, they're not going to accelerate that due on sale clause. Now, you can also use land trusts to protect your personal residence. And it's mostly going to be for primary privacy purposes. Now, at Anderson, we draft a specific type of land trust for your personal residence. It's called a personal residence trust. I know we like to name things very straightforward so that everyone can kind of stay on board with what's going on. So this personal residence trust, this is an example that I just found on DataTree, is a third-party site. You can search property ownership in every county, over 3,000 counties across the United States. I can pretty much go with either the name of the property owner or the address, pull up your deed and ownership of your property in all 50 states. Probably take me about 7.5 minutes, and I can usually do it for free. Some states will charge a small fee. That is not a fee that is going to deter any sort of pit bull of an attorney when it comes to finding out who owns your properties. Now here, what can you see? The trust is owned by Pascal Trust and Carter Coons. Carter Coons is our nominee trustee. So it's our attorney who we list on title on public record as the nominee trustee, meaning a temporary trustee. It doesn't indicate on the deed at all that he's temporary, but what happens is he will automatically resign once the deed's recorded and then give you all of the paperwork to transfer total and complete control and ownership over to you. You hold on to that. You keep it as a pocket deed, keep it in your pocket. You don't record it with the county. So from the public's perspective, who owns this property? It looks like Carter Coons, trustee of the Pascal Trust, owns it, but who actually owns and controls it? Well, from the public record, we don't know. I know that it's one of our clients, or at least in the past was one of our clients, and we set this up for them, unless there's some other Carter Coons out there who's working as a trustee for another company. But I couldn't tell you just from looking at this who it was. And even if I looked up in our system, I wouldn't tell you that. That's private information, right? And so you get what's called anonymity for your personal residence. We are typically attaching this personal residence trust directly to your living trust. So we're initially drafting with your name so that you can then maintain your homestead exemption. A homestead exemption is going to be a state constitutional protection of the equity in your home from creditors and in the case of bankruptcy. And it also, most of you will most often recognize it as a property tax cap or a freeze that keeps your property taxes low. So for example, in Las Vegas, we have a 3% cap on homesteads. So even though everyone's moving in from California and causing our property values to go up, and thus our property taxes to rise every year, my homestead taxes won't go up more than 3%. And so there's varying different benefits depending on your state. Disabled veterans in Georgia pay 0 property tax, which is great. That should be the rule in all states. So clients are very concerned about transferring to a personal residence trust and maintaining that exemption. And the good news is that we can, because that exemption is allowed for an owner who owns their property through a revocable grantor trust. Those are our keywords for the night. Personal residence trust is a version, a type of revocable grantor trust, so you can still maintain your homestead exemption while also getting privacy. Because if somebody looks up your property, it's not going to say your name anymore. It's going to say the name of a trust and the name of the trustee. Some states will only list the trustee. Some states will only list the name of the trust. For example, Texas. Texas doesn't list the name of the trustee. It only lists the name of the trust there. All right. We could go through a couple of questions. When you sell the land in a rental property, does it follow the rule of 1031? So yes, if you're doing a 1031 exchange, you can sell through a land trust. That is a trust is a disregarded entity for tax purposes. A 1031 is a tax strategy. So as long as your original property and your replacement property hit your tax return in the same tax return, you can actually close from your name into a disregarded LLC or into a land trust or from one disregarded LLC to another disregarded LLC. It's a bit of a misnomer that you have to close in the exact same name when doing a 1031. We really want to take a look at your whole structure. And as long as the original property and the replacement property hit on the same tax return, then you're going to be good to go in terms of a 1031 exchange. So if you would like to do a free strategy session, here's a QR code. I can also throw into the chat a link if that's easier for you all. What we're going to do is you sign up. You're going to sit with one of our business strategists, senior strategists, and they're going to sit with you for 45 minutes, talk about all of the assets you have, all of the things you're worried about, and come up with a customized plan. It's called our wealth planning blueprint. We'll assess your liability exposure, and then we'll provide solutions for your specific situation based on where your assets are held. Now, we were talking about this at the beginning that Dawn has seen, and we've all seen so many gurus out there pushing land trust, land trust, land trust. I run our land trust and deed department at Anderson, and I do not recommend these in every situation. We're using them for very specific reasons to solve problems. And if you saw a handful of these problems tonight, right? HOA rules, trapped real estate, buying at auction, wholesaling, flipping. If you don't have that problem, then we don't need to use a land trust. If your state allows you to transfer into an LLC and not have to use a trust, then let's just do that, right? If your lender isn't going to trigger your due on sale clause by transferring to an LLC, then let's keep it simple. My high school chemistry teacher said, keep it simple, sugar bear. We want to do things simply but effectively, because that's when you're going to actually maintain your structure. And a structure that's not maintained, that's too overcomplicated for the owner, is going to fail because you're not going to do the things that you need to do to make it hold up in court. So we really want to get with you, get exactly what you're doing, look at your goals, look at your investments, and create a customized plan for you. Hey, Don.
Amanda, let me ask you a question that I get all the time. Um, and I think people think that a land trust is going to say right at the top, land trust. It's not, is it?
No,
We're,
it
we're,
doesn't. And it actually shouldn't, especially if you are investing outside of Florida. Because if you're in California or Michigan or Washington or Texas and you go out and say, I'm using a land trust, then the third parties you're working with will say, oh, we don't use land trusts in this state. And that's true. They don't use Florida statutory land trusts or Illinois land trusts. What we're doing is a California specific revocable grantor trust that holds land. But that just doesn't quite roll off the tongue the same way as land trust. So we're still going to use the shortcut there.
and there is so much history but behind land trusts. They and rightfully speaking, they were created at the beginning in the 1920s. They were uh, Chicago land trusts. The mafia owned a lot of land in Chicago in the land trust, so nobody would know who they were. And so they've received a bad name. But in your land trust, does the word land ever appear?
Not really. There was a small period of time where we were including it on Florida land trusts, but that was not actually statutorily required by the Florida land trust statute. So we removed it because it just ends up causing problems for you when you're working with banks or when you're working with title companies or when you're working with insurance. Uh, you can go to an insurance company, and if they're not used to, if you don't you're in Texas and you don't get a rep that has experience with Florida, then they're just going to get confused by that. So we don't want to cause any
We're,
unnecessary
so we're
issues.
really masking it to look like a revocable living trust.
Hmm.
It's just it has a very different purpose. It's not going to be your whole estate plan. It's
Correct.
just to hold this one property, mask it so the mortgage company, so the county recorder thinks it's a revocable living trust, which it is,
Hmm.
but they think it's for estate planning purposes. Okay,
Exactly. But it is not meant to replace true estate planning. It's a much simpler
correct.
document, although still plenty of legalese for you if that's what gets you going. But it
Right.
isn't meant to name your children or say what happens when you die. So if we really do still want to do formal estate planning, attach your personal residence trust to your living trust and then take your entire asset protection structure and fund your living trust with that. Hmm.
Right. All right. Um, did you say data tree?
I did. That was the third party search engine that I used to pull up that property. We have a couple of different resources that we use. Uh, but yeah, that was one of them. We use Parcel Quest. We actually go to the state and the county websites directly a lot of the time as well.
Robert asked, could they subpoena Carter Coons in a deposition? He could simply deny that, look, I resigned. I don't know who this is. Would
Yep.
there be a need for a deposition?
They could try, but and he does get, I mean, Clint, our founding partner and Carter's father was our nominee trustee for many, many years, and they still get calls. They have a completely separate cell phone because they get calls and they get attorneys reaching out, people who have searched up property ownership and are looking to buy the property, and they just essentially tell them, hey, I'm no longer the trustee. You haven't completed service of process. And they always get the question, well, then who's the trustee? And I think it's kind of fun for them to say, well, that's for you to figure out. Bye. Because you can't subpoena somebody who is no longer in that position. So they would never have to show up to a deposition. The trust documents themselves actually prohibit the trustee from revealing any information about the trust or the beneficiaries. Because you as the
And
client retain complete control. Even though they're on title, they only serve as the trustee temporarily, a mere weeks. And then within the trust documents, they have essentially no power to do anything without written consent of the beneficiaries.
and it's attorney-client privileged with Carter and Clint anyway, and
Well,
they don't have to
technically,
disclose them.
yeah, they're not going to disclose any client
Right.
information.
Right.
Yeah.
Right. How do title companies deal with these invisible owner entities?
Sure. So that's where it can get, if you're selling property, we never want to give third parties the assignments. So when we send you your trust, your land trust packet, it's going to come with three things. It's going to come with the certification of trust, which is a one-page highlight reel. So it's going to say who the parties are, who the successor trustees are. It's going to be signed by the beneficiaries and the trustee. You're going to give that to an insurance company, a bank, a title company. That's what you're going to initially give a third party if you ever need to prove that your trust exists. Now, you'll also have the longer trust agreement. And sometimes you may need to give it to them. I know I was changing insurance on one of my properties. I gave them the certification. They said, hey, we want to see the whole trust agreement. I said, okay, that's fine. My insurance company is not going to turn around and put my trust on the public record for everyone to see. My bank's not going to do that. But we never want to give the assignments to anyone because that is the situation where I've seen problems arise. We had a client in California who was selling their property. The title company asked for the trust, which makes sense. We need to know who owns and controls the property. They gave everything over. So they
Oh,
gave the
oh,
cert, they
oh.
gave the agreement, the trust agreement, and they gave the assignments. And because that title company in California wasn't used to working with trusts that assign beneficial interest that way, they just kind of backed away. We were able to solve the problem very quickly by transferring the property back to the client's name, and they were able to close normally. But so ultimately wasn't a bad result at all, but it did cause a little panic there. So you just don't want to give the assignments over to anyone, any third party, especially a title company.
Okay, good. Somebody asked, what's the best use of a land trust for a real estate investor who buys and holds? Can I chip in on this for just a
Sure.
second? I see people who try to do land trusts all the time, and they've owned the property for 20 years, and it's in a small town. Everybody knows that they own the property, and then it disappears into a land trust. I'll tell you, 95% of the people I see trying to do their own land trust always screw it up somehow. They always leave little breadcrumbs, or just flat out and so the people aren't stupid. If there's a lawsuit, they're going to come to you, set your little butt down in a deposition, and say, "Do you own this land trust?" Well, you can't lie. If you're going to use land trust, do it right. I always like, at least the first time, have have Amanda do this for you. But every state and county is going to be a little bit different. You've dealt with that so many different ways. Every
Oh, yeah.
township.
That's why we like to do deed prep as well. So my department will draft the trust and the deed at the same time. We've just seen so many people who mess it up. It's the final piece of your asset protection structure. Like you've spent the time, the money, the energy, the stress getting it set up, and moving the property in is that final cherry on top. You just want to have a bow on it. And there are just so many little tiny speed bumps that you can hit before the end. Had a client in California who they actually had us draft their trusts, but and their deeds, but they wanted to take the deeds into the county office themselves. So the deeds were perfect. No anonymity issues, had our company address to where the property tax statements would be sent, not the client's home address. Nothing on the face of the deed that would indicate that they were still connected to the property. Well, he walked into the recorder's office because it was around the corner from his house. He thought it would be easier and faster. They slid a cover sheet over to him, said this is required for each recording. He filled it out with his name, his phone number, his email address, and his home address because that's what was required by the form. Whoever's recording it had to give that information, and he was doing it himself. That cover page got recorded with each and every deed. So 12 properties, completely blew his anonymity right at the finish line. Now, when we draft the deed, we do still fill out that cover sheet, but it has our information on it so that when you send the deed back to us, we send it to the county, you're still anonymous. He didn't know about the cover sheet because we didn't send it to him because he wasn't supposed to record the deeds himself. So there are just a lot of anonymity issues, and that can really derail everything you've worked so hard for. And it's like tripping at the finish line of a marathon. It's really sad.
Talk to me about the difference between a warranty deed and a quitclaim deed when you're using a land trust. If you're trying to, you own a property already, and then you quit claim it in, isn't that like a major breadcrumb? And why? Explain
Yes.
that for us.
So there's different types of deeds. Most people will say, well, I'll just quit claim my property to my LLC. A quit claim deed is essentially saying, I'm giving to you everything I own. Now, I might not own anything. I can fill out a quit claim deed for a property I don't own and give it to you, Don, but I didn't guarantee I owned anything, right? So if you're a third party buyer, you would never accept a quit claim deed from someone because you're not getting any guarantees. You're not getting any warranties with it. So you only see quit claim deeds between related parties. Parent quit claims to their kid. You quit claim into your own living trust. You only see quitclaim deeds in those circumstances. So if you see quitclaim on title, that right from the get-go indicates a relationship between the two parties. So if you quitclaim into your land trust, sure, your land trust might be set up anonymously, but I'm looking that up. I know that you're connected to that trust. Because a third party, if they own that trust, they would never accept a quitclaim deed for you. And so that's why you always get a warranty deed when you're buying property. That's why you should always use a warranty deed or a warranty deed equivalent. They are called different things in different states. So Washington, it's called a statutory warranty deed. Nevada, it's called a grant bargain sale deed. California is a grant deed. So they're all essentially warranty deeds, which means that the seller is guaranteeing that they own the entire property and all possession and right to the property, and that they're giving everything to you so that you are the full and complete owner. So that's why we want to use those warranty deeds.
And a title
Any kind of
company is
transfer.
checking
Mm-hmm.
and making sure that there's no other liens or encumbrances on the property, that you're buying this free and clear. You would always buy a property with a warranty deed, and yet I see people transfer their ownership and use a quit claim deed, and
Yeah.
anybody with a brain knows that it's them.
Yeah.
Yeah. Okay. You know what? We got a lot of questions, and I'm taking up too much time here. So let me. Did we get question number one for out of state rents, third party property? Did you answer that one already?
No, I didn't. Generally, when you're setting up a bank account, though, if like I'm in Nevada, I walked into my bank to set up a account for my holding company, and the banker will ask you, will you receive any income from this state? And if you say yes, because your rental property's there and you're paying rents directly to your holding company, then they will make you register your holding company in that state, which we don't want to do because the state may not be anonymous like Wyoming is. So that's why you would get a bank account for the trust instead. Now, if you have a state specific LLC, you would simply collect rents in that LLC instead. But you generally can't collect rents from a non-Wyoming rental in your Wyoming holding company.
Okay, sorry. There's the answer to your question, Kim. Do you know if there's any advantage to obtaining funding from hard money lenders for a flip through a land trust?
The advantage is they're a little more, this is a legal term, they're a little more loosey-goosey about looking at the documents. Land trust is not a well-known strategy to non-real estate investors, so a traditional lender most likely won't let you close in a land trust. I mean, if you think about it, he who has the gold makes the rules. And if I want to see you clearly connected to the property, well, a land trust is set up to be anonymous. So if a big lender is probably not going to fund that type of thing. So a hard money lender, you're more likely to do some alternative financing and be okay with the land trust.
Rudolph, would the land trust replace the purchase sale agreement, or is a purchase sale agreement still needed in addition to the land trust?
You still want that purchase sale agreement. It's just that the buyer will be the land trust. And you, as the trustee or whoever the trustee is, would be signing as the buyer of the land trust.
Okay, good. Surdy again, don't the property and tax assessors need a point of contact to send the annual assessment to? Who do they send that to if it's a nominee trustee?
Yeah, so you list the address where you want the property tax statements to go on the face of your deed, and you can update it online typically. For our clients, we use what we call our company assistance program address. So it's a physical office that they rent space from in Las Vegas. So the mail all comes to us, we scan it, we upload it, send it to you. So you would want some other address. You don't want to use your home address. Especially you don't really want to use the property address if it's a rental because you just don't want your mail going there. So you would have to have some other PO box or virtual address to send it to.
And that doesn't have to be the nominee trustee's address.
No, it
That could
doesn't.
be, yep, okay, so, okay. What is the best use? Oh, we already answered that one. Clear that one, clear that one. Okay. Does Nevada have land trust statutes? And the answer is no, but they recognize revocable grantor trusts.
Exactly.
Yep.
Mhm.
Okay. Jeff, it's good to see you on, Jeff. If all the transfer of a trustee documents are private, not recorded anywhere, what prevents the old trustee from transferring the trust to a third party after he's transferred it to you?
Well, that's why it's really important to work with a reputable company if you're going to be using them as the nominee trustee. Um, our two nominee trustees are attorneys, so they are follow the rules of professional conduct because their bar licenses are on the line. Also, we would never risk the reputation of Anderson Advisors to steal somebody's property. Carter and Clint are pretty prolific real estate investors themselves, so there's no reason for them to engage in that type of fraud. If you are using your own third party, you would just want to make sure that they're trustworthy there. The land trusts we draft give the trustee no power. If they want to transfer the property, they're only legally allowed to do so with the written consent of the beneficiary, which is you. So they're not allowed to do that.
It, the name trustee scares people because they think they have all the power, but not in the document because you're giving them enough power to sign the deed and resign. Those two things. That's all they can do.
That's all you can do.
I love it. Okay, that's good. Okay, Christopher, the VA disability of 100% in Michigan makes property tax exempt. Okay, well, that's good. I was going to ask if there was a land trust for personal property. Yeah, we call it a personal property trust.
Personal residence trust, and it does allow you to maintain your homestead exemption because it's just like a revocable grantor living trust. So yes.
Although Michigan doesn't offer much of a homestead protection, but it does preserve what little Michigan offers. Okay,
And that
how do you
property
close?
tax cap.
Oh,
That's
oh,
what
there we
people
go.
are worried about, Don, the property tax.
All right. And in some states, there's a property tax reduction
Hmm.
for homesteading your property. Not a
Exactly.
lot of states, but some of them. How do you close out or shut down the trust after you sell the property?
So there's two ways. Once the property is taken out of the trust essentially ceases to exist by operation of law, just automatically. You can also just revoke the trust. So I revoke the trust, the name of the trust, you sign it, it's revoked. The trust isn't recorded anywhere like a LLC is registered with the Secretary of State. So to dissolve an LLC, you have to file and pay a fee to the state. The trust isn't recorded anywhere. So it's all just your personal documents. So you can, it just kind of expires once there's no property in it. Or if you wanted to formally revoke it, we have those templates. We can draft all that for you as well.
And Susan, when you create a trust, you get it signed and notarized, but it's really formed when you put your first asset in it. That's when the trust becomes effective. Likewise, if you pull all the assets out, it doesn't own a bank account and it doesn't own a property. It is essentially dissolved, although a formal dissolution might be in our order. Is that fair to say?
Yeah, that's fair. And with our platinum membership, it's on this slide at the very bottom. You get access to 10,000 plus templates in our forms library, from contracts to lease agreements to property management agreements. And so all of the additional ancillary land trust documents are also there. If you wanted to revocation of trust, you could download that, fill it out, sign it, stick it in your file cabinet. You're all done.
Cool. Okay, Wendy, what are the advantages of using a land trust instead of just using an LLC to own my property?
Mhm. So first, it's a little more anonymous because you don't see the connection to the LLC at all because the trust isn't recorded. So you have an extra layer of anonymity there. And then you're also going to avoid transfer tax or property tax reassessment if your state doesn't is going to charge you that to go straight to an LLC. A lot of states say, "Oh, we get it. You're putting your property into your own LLC. We understand that it's still yours. We're not going to charge you." But a lot of states still will. So the trust will usually avoid that there as well.
Including Pennsylvania, where Wendy is from. Okay, you've got it. You've got some funky rules in Pennsylvania about transfer fees. Do you want to hit on that for a minute?
Yeah, Pennsylvania is one of those states that the land trust might not be worthwhile because they charge the fee based on who will ultimately get the properties when you pass away. So they're skipping a level to charge what happens when the trust dissolves, which is a very, very weird way to do it. And none of the other states do it that way. So, and then Pennsylvania tends to have a fairly high transfer tax. So, there we will draft deeds directly into an LLC, but we'll have you hold on to it as a pocket deed, meaning you won't record it until something pops up that potentially has some liability there. So you don't get great anonymity in Pennsylvania. But if you do see a lawsuit on the horizon, something happens, then you can go file those pocket deeds that you've had. The ownership in the LLC will is effective once that deed was signed. So even if you signed it 2 years ago, 5 years ago, your ownership will relate back to that date. And so if something happens in the interim, you simply go and record that deed after the fact. It's as if it was in the LLC since you signed the deed, which it was legally, and then you have that protection. But Pennsylvania is a little rough with anonymity. You don't get that aspect of it, but you do get the legal liability protection of the LLCs there. So that is one situation, Pennsylvania, where I actually wouldn't use land trusts. I would just transfer properties directly to the LLC. And that's why a
Stu,
customized plan is needed for each person, depending on where you're investing.
Students, okay, out in my garage, I have a 4 foot pipe wrench. I inherited that from my dad. It probably weighs 40 pounds. I don't use my 4 foot pipe wrench very often. When I do, it's because I need a 4 foot pipe wrench. I went out several years ago, and my son was using my 4 foot pipe wrench to drive nails in a 2x4. Oh, okay. Dad learned something. I never considered that as even though there's three hammers on the pegboard, he's using this 4 foot pipe wrench, and you could use it. A land trust is a specific tool for specific reasons. We don't use it for everything. I don't use my pipe wrench under the sink because it doesn't fit, and I don't use it to measure things that are 4 foot long because I have a tape measure. But when I need a 4 foot pipe wrench, it's a great tool. And I think what Amanda is saying is it is a specific tool. We use it for specific reasons, but there are great benefits that maybe we could be using it more often. Is that fair to say, Amanda?
That is fair to say. It
Okay.
can be very versatile and solve a lot of problems that come up for investors, like we talked about for the last hour, but it's not going to work for everything.
Yep, there we go. Okay, Jeff, if all the transfers of trustee documents are private, oh, I think we answered that.
Yeah, we did that one.
Okay, got it. Done. Thank you for sharing. You definitely make this easier to understand. Thank you. Okay. Anonymous, what is the benefit of placing your personal residence into a land trust? You know what? I'm going to cover, both Clint and I are going to cover this at the next summit. But is there something you want to, it's mainly anonymity, isn't it?
Yeah, and with your primary residence, especially if you're renting out a room, it's not anonymity from your renter. It's anonymity from the other direction because you're out there in the world. I don't know, maybe you're a good driver, but even the best driver will rear end someone once in a while. And then they're looking at what you own. If you've got a particular, oh no, suddenly my neck hurts, I'm going to go to an attorney. Okay, well, what is that attorney going to do first? They're going to look up your name and see what property you own. And if your home comes up and it's a nice home that they can pull up on Google and Zillow and see the value and it's high, then they're going to want to sue you because they know that there's a big pot of gold at the end of that. But if they pull up your name and nothing shows up, well, maybe it's not worth their time. Or worst case scenario, maybe they're just settling for the insurance maximums, which is great. That's why we have insurance, right? So The residence trust is more to take that target off of your back so you don't become a litigant attacked by lawsuits for these frivolous lawsuits.
And frankly, anybody could, I guess, follow me home and find out where I live. But in a lawsuit, they know my name. Okay, yeah, I caused an accident, but they can really only attach the things that are in my name, and the home is no longer in my name.
Right.
It's in a trust.
Yep.
Okay. Should a land trust be used to purchase investment properties in Texas?
It can be. It depends on your situation, how you're buying, what type of financing you're using.
Right. If you're doing subject to, yes, it'd be great. If you've got a homeowner's insurance or association, yes. For every single property, probably not.
Maybe not. Hmm.
Yeah. So you go back and listen to this again, and I think it'll be more clear. Wendy, who actually owns the land trust when I open it for my properties? So, in other words, who's the beneficial interest holder? What is the entity, or what exactly does the IRS consider a land trust to be?
A land trust is disregarded for tax purposes, so whoever the ultimate owner is. So if you attach it to an LLC, and then that LLC is owned by a holding company, and then that holding company is owned by you, then it's going to show up on your tax return.
Yeah, so Wendy, there's a difference between a pass-through entity like an S corp, or a partnership, because they have to report taxes. But a disregarded is totally invisible. The IRS doesn't see. They don't care that it exists. Your living trust is invisible. They don't care. There's no asset protection with it, but it's an invisible entity. So whoever owns the entity, it's invisible, but it doesn't mean that the tax consequences are invisible to the IRS. It just whoever whoever owns it gets all the tax consequences, good or bad. I hope that makes sense. Catherine, does using a Florida land trust have advantages? Yes, it does. Why is Florida different than all other states,
Yeah.
Amanda?
So Florida has a land trust statute, and what that statute says is that a beneficiary of the land trust is not responsible for any of the actions or creditors of the trust itself. So if your trust is sued, they can't reach into your pocket as the beneficiary. But it doesn't work the same direction. So if you have a creditor, your creditor can reach into the land trust. So we still want to put an LLC structure in between. But in Florida, instead of having one property, one trust, one LLC, in Florida, we can actually do one property, one trust, and then a single LLC with a bunch of them flowing to it. So it gives you like half asset protection.
Okay. Okay. So it protects you from inside
Hmm.
liability, like corporate veil protection, but not like charging order protection like an LLC would.
Exactly.
Okay. Good. All right. Wendy, how many land trusts do I need if I got multiple properties? I think is what she's asking.
Yeah. The default is we want one trust per property, and in everywhere except Florida, one trust per LLC.
Okay. Good. Good rule of thumb. How do I fund the trust?
You just deed the property into it. You transfer the
Or
property into the trust. And that's going to
and
be
do I
done
need
via deed, because it's real property. That's how we hold title to real property, right? Now, if you have a mobile home, or a tiny home, or a timeshare, or maybe a co-op, you might not own the property via deed, in which case we're not using a land trust. We have an alternative trust for personal property, not to be confused with your personal residence, but a personal property trust where for a co-op, you typically own, these are common in like New York City. You buy an apartment building, but you don't own that building. You own shares in the corporation that owns the apartment building. So then we transfer your shares into a personal property trust. But for a land trust, that's going to be for real estate, and that and ownership or the trust is funded via a deed transfer.
Does every land trust need its own bank account?
Not necessarily. For the most part, you're not going to be opening a bank account for each trust because you're the assignment of beneficial interest to an LLC. That LLC already has a bank account. So let's just collect rents there. If you've got 10 properties, 10 land trusts, 10 LLCs, I don't want to tell you to go get 20 bank accounts. Let's just collect the rents in each of the LLC accounts because each LLC should have its own bank account anyway. We don't need to double up on the bank accounts. My situation in Nevada is slightly different, right? So a customized plan. I don't have a Nevada LLC, so I can't collect rents in my Wyoming LLC. So I collect rents in my land trust, but it's still just one bank account for one property.
Can land trusts help with oil royalties, or is that the right tool to be using for oil royalties? Should I use a different type of tool?
Yeah, I wouldn't use a land trust for oil royalties because you're not necessarily owning the land that way. You're typically investing in some sort of partnership entity. And so you're owning membership or shares of something. So usually oil, gas, we just do through an LLC.
Mineral rights, there's a deed to it, but that could probably be held in an LLC. Yeah, Wayne. It's a good question, but it's probably not the right tool.
Yeah.
Okay. Do I need my land trust for each property in Wyoming, or should I have my land trust for each property in the state where the property? Well, Wendy, land trusts are not state specific. They don't have to be filed with any state agency. They just have to be recorded wherever the property is. And so, could they all be held in one Wyoming LLC, or do I separate them in different LLCs, which are then held? How, we'll walk through that one more time. You had some
Yeah.
really good illustrations.
Yeah. And actually, let me see if I can very poorly draw something for you here. So we have the proper, oh, can't see red. I made that mistake once. I was doing a presentation and it was a blue background and I had red pen and everyone's like, people who are colorblind can't see red on blue. So you have your property. We're putting it in a land trust, right? And I apologize. This is not very good drawing. That's going to then be connected to your state specific LLC. LC. The land trust will reference the state that the property's in because we want it to be formed under the laws of the state of insert the blank, right? So if your property is in New Jersey, we want the land trust to be formed under the laws of the state of New Jersey. We don't want it to reference Hawaii or Florida, right? So the trust itself is going to reference the state. The property LLC is also going to be in the state where your property is located. And then you have the Wyoming LLC, which is there to offer the anonymity and the charging order protection.
Okay, so, and this is for holding properties, not necessarily for flipping properties.
Right. With flipping, we're using a totally different structure. You can incorporate land trusts like I discussed, but we're typically wanting to flip in a C corporation because of the tax benefits, right? We don't want to get tagged with dealer status. We don't want to pay self-employment tax on our gains. So we're not using the same type of structure for our passive investments that we are for our active activity like flipping.
Okay, Maria, good to see you on. Thank you. How does the land trust affect Prop 19 in California? Property tax reassessment.
Sure. So I'm originally from California, so I get this question a lot because Prop 19 changed the way that properties are taxed. So it doesn't affect it at all. If you have a property and it's grandfathered into Prop 13 in California, that will not change when you transfer to a trust because it's still your trust. Prop 19 comes into effect when you transfer your property to a third party like your kids. If they're not using it as their primary residence and it wasn't your primary residence, that's when the tax will jump up. But you won't get increased property taxes by just transferring to your trust.
Let me add something to that because when you're doing the deed, the quit claim or the warrant, when you're doing that, in California, you also fill out this preliminary change of ownership form. You screw that up, and they're going to reassess the
Yeah.
properties. But it shouldn't if you fill it out right. And so if you don't know how to do it, this is where Amanda and her team come in. So, great question. Thank you. Is it a good strategy to put Los Angeles real estate in a land trust with a single member LLC as trustee, then have multi-member Wyoming LLC? Okay. In California, are you using land trust in the Wyoming or using statutory trust? I, I know we don't have a lot of time, but how do you do California?
Yeah.
We do
California
things
is
the
a little
same in
tricky.
49 states, and then we do California.
Yeah, California is a little tricky. There's the franchise tax board fee. So a lot of people will bend over backwards to avoid paying that $800 fee, right? Um, the most straightforward answer is to use a California LLC, pay the fee, build that into your rents. We have an alternative strategy. We actually use what's called a Wyoming statutory trust. That is a business trust formed in Wyoming and then foreign filed into California. And it offers the same liability protection as an LLC. One of our state planning attorney calls it an LLC in drag. It's an LLC. It just looks like a business trust. It has the word trust. And for now, those avoid the franchise tax board fee, that $800, but that's kind of a loophole at the moment. So California could close that loophole. You could do a land trust to a Wyoming LLC. You'd still want that statutory trust blocker because when you file, if you're a California resident, because California will ask you about all LLCs that you own. So if you own the Wyoming LLC directly, you're going to have to report it.
Okay. Perry is asking, does a personal residence trust file an annual tax return?
Nope,
No, no.
disregarded.
And no filing fees with the state and no,
No registered
um,
agent fees, nothing.
yep. Are land trusts good in California? Again, there's no state statutes. I'm skipping over and
Yeah,
you're trying to follow me and I'm going that
we
we had too
use
many
land
questions
trusts
for the
in
time we
every
got.
state. We have clients who use land trusts in every state. Pennsylvania, Wendy, is just the one where it's the one state where it's not going to get you anywhere because of the transfer tax issue. But every other state we do land trusts. California is our third most popular place for investing for our clients, so we do a lot of land trusts in California.
Okay. Beverly, is there one vehicle, I think we're talking a legal entity, where I can hide all your assets from creditors and everyone else?
Yeah, I mean, you use this structure here, typically a three-tier, two-tier structure with the holding company for real estate. You can have a safe assets LLC to put your brokerage account, your stocks, your crypto, your gold, all of those types of things in. And because these are located in Wyoming, Wyoming doesn't publish manager, member, owner information. So nobody can tell that you own those items. So that's why we're typically anchoring these asset protection structures in that state because nobody can see who owns them.
Okay, Lisa is asking, what's the difference with regulations? I currently live in Virginia, and Lisa, that is a very broad question, and there are over 5,000 counties, and I don't know how to answer the question. But is there anything specific about Virginia?
Um, Not really. That Virginia is one of the states that does have a land trust statute, but we don't actually draft our land trusts under that statute. We're simply doing a revocable grantor trust in every state except Florida.
Okay. And Wendy, no, you don't need a resident agent for the land trust. We that would be LLCs, corporations, limited partnerships, and maybe statutory trusts. What are the disadvantages of using a land trust for your own properties?
There really isn't one. I mean, Actually, if you have a homestead exemption for property taxes that you had to apply for when you first moved into the property, you will have to reapply. Because the county only sees that your property went to an anonymous trust. They don't know that you still live there and that you own it through the trust and that you still qualify for the exemption. So you have to proactively reapply. If you don't do that, they will send you a notice and they will likely send you more than one. But if you proactively apply, it's fairly simple process, but you do have to redo that.
Okay. Anything specific about New Jersey?
Not that I know of. You do have to use a local attorney to draft and record your deeds. That's a attorney deed filing state. So Anderson, we have a New Jersey attorney. He is just not located in New Jersey. He's based out of Utah. So in that case is one of the rare instances where if you have work done by another firm, we will actually review it to make sure that your anonymity is going to stay in place. We don't do that everywhere.
Okay. Chris is saying, I purchased a property from a tax sale. They used a quit claim deed. Should I be worried?
Was it from like the county? Probably
I don't know, but
not. I mean, I don't love getting anything via quit claim deed from a third party because all they've transferred to you is everything they own. So if they didn't own the property legally, then you got transferred nothing.
yeah, it is quit. It's QUIT. It's not quick. It's quit. They're quitting or abandoning all their claims to the property, and whatever they had was they're giving that to you. That doesn't mean that there's any other liens or encumbrances on the property. They're just saying whatever we have, we give to you. That's all the quit claim deed is they're quitting or abandoning their claims. It would make me nervous. Let's just say that. All right, we've got a few more questions, but I think we're out of time. I don't want to. I don't want to infringe too much on Amanda your time. I so appreciate it. If you have more questions than that, I strongly encourage you to do the consult, do the strategy session. Just click on that, or what was the link? I guess it's in the chat screen. There we go. There's a link, right? Click on that. That'll take you right to the consult. Amanda, any closing comments?
No, I just thanks for having me again, Dawn. This is really fun. Haven't seen you since the CTA went crazy, so I love
I
coming in,
know.
talking to your students. It's nice because your students are so well educated. So I'm explaining things and you're like, it's charge and order protection, everyone. I'm like, oh, this group knows what charge and order protection is. They know what inside and outside liability is. So it's nice to talk about these strategies with a more sophisticated audience so we can really get to the more higher level stuff, not just the basics.
And we try really hard to keep them educated but we have new students every single day, and so we appreciate your expertise and your very kind way of explaining things to us and very relatable. Amanda, we love you. Thank you for being here. We'll have you back anytime you want to come share some of your experience. Give her a little, yeah, thank you for those hearts. Give her a little love. We appreciate it. Amanda, have a great evening. All the rest of you, thank you for being on. We appreciate it. This was recorded. If you have questions, go back and listen to the recording. It should be sent out tomorrow. Thank you for being here, Amanda. Have a great night. Bye bye.
Good night, everyone. Bye bye.